in a joint managing conservatorship situation, typically those decisions are going to be shared. The major decisions, like who's going to make decisions about major medical decisions, who's going to make decisions about psychiatric and psychological issues, who's going to make decisions about educational issues. In a joint managing conservatorship situation, those duties are normally shared. Honestly, if you think about it, it makes sense that if we're making major decisions for our children, both parents should get to be involved in that. That's assuming that you and your spouse can get along for the best interest of the children. And if you can, great. You should be able to talk with each other and make those decisions together. A lot of times you'll hear about something called a tiebreaker. So we hope that parents can act in the best interest of their children and make decisions jointly for the best interest of their children. But a lot of times you got divorced for a reason. There's conflict there. And sometimes one parent will use that conflict against the other parent just to get back at them for something, and it's really not even about the kids. To avoid those situations, to prevent us having a stalemate and not being able to reach a decision, a lot of times your lawyer will recommend having something called a tiebreaker. And so if we can't come to an agreement on major educational decisions, or we can't come to an agreement on invasive medical decisions for our child, we can designate a neutral third party as being the essentially the tiebreaker, the person that we're going to follow their recommendations. So for example, in a situation where we're talking about invasive medical decisions for your child, if we designate the child's pediatrician as the tiebreaker, then you and your ex-spouse are going to follow the pediatrician's recommendations if you guys can't come to an agreement on your own.